Thank you for joining Jennifer Schausman Associates in our 2019 Webinar Wednesday series. We are coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. These are all complimentary. If you have questions for our speaker today, you can email her directly with the contact information you'll see on the last slide. Right, just a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website. We have an upcoming event that you can find more information here, also on our website. And we do offer advertising, so you can send me an email if you would like more information on that. And our webinar today is sponsored by AccuTrack, and here's a short message from them.
AccuTrack Consulting and Accounting Services is an 8A WOSB CPA firm committed to supporting entities sustain growth in government contracting. Our outstanding DCAA accounting solutions reduce audit risk, improve cash flows, and give you peace of mind. Contact us today to learn how we can enhance your DCAA accounting efforts.
All right, let's go ahead and get started. Our speaker today is Maria Panichelli, and she's going to be covering bid protests, when, why, and how. Maria, thank you for joining us, and I'm going to go ahead and hand it over to you.
Thanks so much, and thanks to everyone out there for joining us today. As many of you probably know, this is the first in a two-parter. We're doing a 12 to 12:30 and a 12:30 to 1. Today we're going to talk in the first part kind of about the general overview of bid protests, and then we're going to get into some more advanced strategies in the 12:30 session. But as Mallory said, we're going to be starting with the when, the why, and the how. Next slide, please. So in order to understand all this, I think it's important to just get a brief, summary of some fundamental concepts about bid protests. And the first thing is to understand what a bid protest is and how it differs from size and status protests, because a lot of people confuse those different types of issues. So bid protests are when a contractor brings a challenge regarding the way in which the agency applied either the evaluation criteria or the solicitation terms or the applicable law when making a source selection decision. So it's a challenge brought by a contractor in relation to a specific procurement where they say, hey, the agency mucked something up here. They didn't do something right in the source selection decision. And, but for that, I would have gotten the contract award or one of the contract awards. Size and status protests are a little bit different. They don't necessarily concern themselves with anything the agency did wrong. Rather, they focus on whether or not the awardee was actually eligible for the contract in the context of set-aside contracts. In other words, bid protest is going to point at the agency and say they messed something up. They did something wrong. They didn't follow the solicitation terms. They didn't follow the applicable law. The source selection decision was messed up because of the process that the source selection committee went through, whereas a size or status protests are still going to be brought by a contractor, usually a disappointed competitor. But they're going to say, hey, the agency didn't necessarily do anything wrong in selecting these people other than the fact that these people are not eligible. They're not really a small business. They're not really an SDVOSB, etc. So all protests brought by a contractor in regard to a specific procurement, but bid protests challenge what the agency did as part of the source selection decision. Size and status protests challenge the eligibility of the awardee. There are also size investigations and status investigations. Those are agency initiated and kind of outside the scope of what we're talking about today, but you should be aware of them because, other contractors or competitors raising these issues are not the only time they can come up. Agencies can kind of sua sponte decide to undertake an analysis all on their own. Next slide, please. So the next concept that it's important to understand is what laws govern or relate to the protest process. In other words, when we talk about the government or an agency not following the applicable law, for the most part, what are we talking about? Well, like most things with government contracting, it starts with the Bible of government contracting, the FAR, the Federal Acquisition Regulation. Now, depending on what agency you're dealing with, there may be supplemental agency acquisition regulations that come into play. For those of you who've dealt with those before, I mean things like the EFARS, the DFARS, the VARs, etc. The supplemental agency regulations that some agencies put out and some subsections of agencies put out that supplement but never contradict the FAR. In addition, there are certain statutes that come into play depending on the substantive issues that you're dealing with. You could be dealing with CICA, the Competition and Contracting Act. You could be dealing with the Vets First legislation, depending on the type of issues that come up in your protest. Also, if you're dealing with eligibility issues, which usually come up in the size or status protests that we just talked about, and not in bid protests, which we're going to be concentrating on today, but all the same, want to make you aware the SBA and the VA regs regarding eligibility for those small business programs can also come into play, every once in a while in the bid protest context, but definitely in the small business set aside size and status protest context. Next slide, please. All right, so final slide on background information and kind of these fundamental concepts that you need to understand. Some of the questions that you need to know, or know the answers to, I should say, and some of the considerations that you need to kind of bring to the table when you're talking about protests, and this is going to impact a lot of what we talk about both in the rest of this session and in the follow-up session at 12:30, is the kind of information gathering you need to do to understand kind of where you're at in the process and what your rights are. And the reason for that is that protests kind of fall into different buckets, and you have to follow different procedures, and you need to analyze things a little bit differently depending on a host of factors. So when I say a host of factors, what do I mean? I mean that what type of contract this is might dictate your protest rights and what issues are protestable. Is it a set-aside contract? Are there issues regarding eligibility or propriety in setting or not setting aside a contract? Is it an IDIQ? Is it a task order? Certain task orders, whether they're civilian or military, have different thresholds, and you cannot protest a task order unless it is over those thresholds. So, understanding whether your contract is, the contract that you're protesting, the procurement at issue in your potential protest, is a task order, and whether you're over the threshold. Those are important concepts. Understanding if it's an IDIQ and if there's anything special that relates to that. Understanding if it's a set-aside or if you're protesting the fact that it should have been a set-aside. All reasons that it's important to understand what type of contract you are dealing with, what type of contract is at issue in the procurement that you are potentially considering protesting. Who are you dealing with is another important thing to keep in mind. And that's important for a number of reasons. Number one, I just mentioned on the previous slide, certain agencies have supplemental regulations. You're going to need to keep in mind not only the FAR and not only some statutes out there, but possibly some supplemental acquisition regulations depending on what agency you're dealing with. Also, depending on what agency you're dealing with, as you know, they're divided up. There's civilian agencies, there are military agencies. As I just, one example that I just used is the task order thresholds are different for civilian agencies and military agencies. So that might be something that, you need to understand about the agency you're dealing with to understand what potential protest rights you have or what limits there might be on your right to protest. Also, in terms of, there are other places where there's a demarcation between civilian and military agencies. One of those we're going to be talking about a little bit later today, the DoD enhanced debriefing regulations, when we get into the timing and the debriefing facts later today. Those only apply if you're dealing with a military agency under the auspices of the DoD. They do not apply if you're dealing with a civilian agency. So it's important to understand what agency you're dealing with and kind of what bucket they fit into with regard to civilian or military. Also important to understand the type of procurement, and this is a big one in the protest context. And by type of procurement, I mean what section of the FAR this is being procured under. Is it contracting by negotiation under FAR Part 15? Is it sealed bidding under FAR Part 14? Is it some other type of procurement under FAR 8 or FAR 12 or FAR Part 13, etc.? And the reason this becomes important is because what type of procurement it is can impact the deadline and, when you have to get a debriefing, if you have to get a debriefing, what you're entitled to or what you're not entitled to in a debriefing. So in other words, how you gather information for your protest and when your deadlines start ticking. So this is a really fundamental and important question to understand the answer to before you start looking at whether or not you are going to protest. And finally, this is sometimes important, not necessarily always as important as the others that I just went through, but what is the scope of work and what are the services contemplated in the procurement that you're protesting? And the reason that becomes important is obviously for substantive arguments to the extent that you think you were evaluated incorrectly, a real understanding of what the scope of work was and what the services contemplated were, and, where you described, your provision of those services in your own proposal or bid is going to be key. Next slide, please. All right, so remember we're talking about the when, the where, and the how. Let's talk about when. The bottom line, as a very general overarching concept, is that bid protest deadlines are really complex. They are confusing. They can be confusing even for lawyers because sometimes of the way that the government does things, even though, lawyers know the rules. Sometimes it's hard to tell what rule you're operating under unless the government, was specific enough in the solicitation. And you have to try to then, cover your bases and go with the most cautious route. But they're complex, they can be confusing, they are strict, and they are not subject to extensions or excuses. And by that, I mean, you get your protest in 5 seconds late, it's past the filing deadline, you're not going to get a pass because it's 5 seconds late. GAO decisions there are a million of them, where there are very small deviations in timing, and basically the government says, I'm sorry, no, you're out of time. They are not lenient on these things. You have strict filing deadlines. If you hit file and it takes 20 seconds to file, and in the meantime the deadline ticks by, you are out of luck. There is no forgiveness in this area. This is not a deadline that you want to be, unsure about. The first thing you want to do when you're talking about potential protest and talking to, your legal counsel is figure out what deadline is applicable and when do we need to file. And the reason that this can be so complex and confusing is that there are different timelines, and I kind of alluded to this earlier, but there are different timelines for different types of protests. There are different timelines for different types of procurement, and sometimes the forums have different rules. So the things you need to ask yourself again are, what type of procurement or contract are you dealing with? Relatedly, was a debriefing required, and why should you care? So taking those two questions together, I'm going to add a little bit of explanation. FAR Part 15 talks about the fact that things that are procured, procurements that are made under FAR Part 15, contracting by negotiation, that's your best value, that's your trade-off, that's your LPTA, that's your competitive range, those types of procurements, the government has to provide a debriefing in those types of procurements. Why does it matter if the debriefing is required or not required? Well, it impacts the deadlines. If you're going to the GAO general rules are you have to file, if you're filing, and we're going to get into this in more detail in just a bit, but if you're filing a protest based on errors in the solicitation itself, you file that prior to the deadline to respond. And again, we'll talk about that a little bit more in just a bit. But if you're talking about a protest where, it's not based on a pre-award issue, you're talking about something that actually went wrong during the source selection process, you need to get a debriefing, and then your deadline starts ticking from the date of that debriefing. That is only the case if it is a required debrief. So that's why it's important to understand whether a debrief was required. It can toll or not toll your deadline. Only certain types of procurement have required debriefs. If you ask for a debrief under one of the other types of procurement, even if they give it to you, it's not tolling your deadline. And they might not give it to you because it's not required. So another thing to keep in mind with regard to when to protest, there are different deadlines. If you're going to the GAO, for example, there's a 10-day deadline, and we just talked about the differences about when that could start ticking by. But there's a 10-day deadline if you want to just be timely and file your protest. There is a 5-day deadline if you want what's called a stay. In other words, a pause on all proceedings. Nobody can go forward with the contract. Nobody can start performing until the protest has been finished being litigated, until the GAO actually rules on the protest. So you have to keep in mind those issues. Best practices, as I said, because these are complex, confusing, and because not only are they complex and confusing, but the deadlines are so strict and there's really no forgiveness. Best practices is as soon as you think there's a potential protest brewing, as soon as you get that first notice letter, as soon as you're aware that the contract went to someone else, it really makes sense to contact a legal professional, talk about what type of procurement this was, calculate what deadlines you're dealing with, talk about strategy for a debrief, talk about questions you can and can't ask in a debrief, etc. Next slide, please. So we're going to talk a little bit about the triggering moments that should kind of give you a red flag that it's time to do something. Next slide, please. All right, so when you're going through kind of the trajectory that you go through with the procurement, usually starts with the solicitation. So you see a solicitation. Are there problems with the solicitation itself? Are there terms in there that are unduly restrictive? Are there contradictory terms? Is something ambiguous? Is it something that isn't answered in that question and answer period with the government? If so, then you have a basis for a pre-award bid protest based on errors in the solicitation. When do you want to file that? As a general rule, you're going to need to file that before the deadline to respond to the bid or the proposal. Or, I'm sorry, respond with your bid or your proposal to the solicitation. Next slide, please. All right, what about if you were in a FAR Part 15 procurement and the government actually selected a competitive range? Did you get a notice that said you were excluded from the competitive range? If you're under FAR Part 15 and the government does a competitive range analysis, you will get a notice. You should. It's required under the FAR that says, hey, you were kicked out of the competitive range. We're going forward with these other people. What do you do then? That is when you potentially have a pre-award protest based on exclusion from the competitive range. But again, if you're dealing with competitive range, you're going to be under FAR Part 15. You got to get that debriefing. So within 3 days of getting your notice, you've got to get a debriefing and then request a debriefing. Then once you get your debriefing, you can go forward with your protest. Again, that's going to be one of those 10 days from the time that you get your debriefing deadlines. Next slide, please. Next thing, if you're talking about a set-aside contract, and again, we're focused mostly on bid protests today, but I think it's important to just, be aware of the size and status protest issues. When you get a set-aside contract, before the award is made, you're going to get a notice under FAR Part 15 that says, hey, we're going to award to this other company, better luck next time. That is when you have a size or status protest. And when do you file? Within 5 days of getting that notice. You're noticing the deadlines here are 4 days, 5 days, 10 days. They're all very short deadlines, and a lot of them, not all, but a lot of them count weekend days. So again, best practices, call a legal professional that can help you sort this out and walk through the process and make sure you're not blowing any deadlines. Next slide, please. All right, the final stage, and you're going to get a notice of award. Obviously, some of the permutations that we've gone through relate only to FAR Part 15 or only to set-aside contracts, but this is pretty much across the board. You're going to get a notice of award, or you're going to get some notice on FedBizOps. There's going to be something posted saying, that you didn't get the award and someone else did. If you get a notice under FAR Part 15, or if you're otherwise, notified of this, what does this trigger? What is this red flag that you need to be aware of? Well, if it's a FAR Part 15, remember that required debrief. You're going to, within 3 days of getting that notice of award to another person or notice of unsuccessful offer letter, you're going to request your debrief. And then once you get your debrief, you are going to have 10 days to file a protest, or 5 days if you want to stay. Again, always going to want to calculate 2 different deadlines and talk about whether or not you need the stay, whether the stay is important, whether there's any point of protesting if you can't get the stay, etc. And those are post-award protests. Now, if you're under a different section of the FAR, you're going to have to, consult your attorney, talk, with your people, figure out all the answers to those questions we talked about before. What part of the FAR are you under? What type of procurement is this? In order to try to figure out your protest rights. The general rule is always that it's going to be 10 days from the day you knew or should have known the basis of your protest. So if there is no required debriefing, a lot of times that means 10 days from the notice of award. The only time that's going to be told and be 10 days from your debriefing is when it's a required debriefing, and the only time there's a required debriefing is under FAR Part 15. Next slide, please. All right, so now we get into the why protest, and we're going to talk about this a little bit more in the second session, but why protest is going to depend very specifically on, the kind of information you get and what type of issues are out there. So we talked about pre-award protests based on errors in the solicitation. These include things like, hey, this contract was set aside for small businesses, but it shouldn't have been, or vice versa. This contract wasn't set aside for small businesses and it should have been. This is where your rule of two or your kingdomware issues come up. Ambiguous or contradictory terms is another big area where you can get pre-award protests. And by that, I mean, one section of the specs says one thing, another section of the specs or the drawings or, some other section says something else. It doesn't seem like they can really be reconciled and you don't know how to bid it, or you could possibly be bidding it in a weird way or a way that could cost you money later, depending on how you interpret those terms. You can't get any clarification from the government. Maybe you file a protest. Unreasonable or unclear evaluation criteria or evaluation scheme. In other words, the government has set forth, the way that they're going to evaluate proposals or bids, and something doesn't, well, not bids, but proposals, since that would be when you have non-price evaluation factors, and something about it doesn't make sense. It either doesn't seem, consistent with applicable law, being the FAR and the supplemental agency regulations, etc., or it's just unclear, or it seems like, they say in one place it's going to be a best value trade-off, but in another place it seems like they're actually elevating price too high, which is a situation I've dealt with recently. So that's another area that you could possibly protest. And finally, unduly restrictive terms. The government's got a lot of discretion in terms of, what they make their evaluation factors, but every once in a while they get a little too nitpicky. Instead of saying you have to have X amount of projects over this dollar magnitude, they start throwing in, terms about past performance or certain requirements that really just aren't feasibly related to the requirements of the contracted issue. That is sometimes when you can do a protest based on unduly restrictive terms. Another time is when they kind of make the requirements so narrow that, they're seeking a widget and they know that by putting certain things into the solicitation, only one company makes that exact type of widget. That's another situation where you've got unduly restrictive terms. Next slide, please. All right, so that's pre-award protests. Those are the ones you have to bring before you respond, and they're based on errors in the solicitation itself. What about post-award protests or possibly protests based on the exclusion from the competitive range? What are some issues that you deal with there? Well, you've got the non-price evaluation factor issues. In other words, past performance, the technical qualifications. Do you think you were evaluated unfairly on those criteria? Do you think that you were underrated? You've got price issues, price reasonableness, price balancing, price realism, depending on whether or not that was required. In only some cases it is. If you've got problems there, you probably have problems with the trade-off. If you're weighing the non-price evaluation factors wrong and you're weighing the price factors wrong, the trade-off is necessarily going to be skewed. Also, discussions issues. In other words, did the government open up discussions? Were there clarifications or discussions? Were the discussions meaningful? Did they have open and equal discussions with all of the offerers, or were there unfair, treatment of some offerers? And finally, just documentation issues. So these are all, probably each one could have a webinar all in of themselves. But these are just some of the issues that you're looking for. But it's really all about, again, talking about that challenge to how the agency evaluated the proposals and the source selection process. So anything that falls under that category is going to be a why protest. But the most common that you see, or at least that I see, are the non-price evaluation factor issues, arguing over the judgment that the agency had in rating people with regard to past performance or technical qualifications, etc. Next slide, please. All right, so where do you bring your protest? There are three primary forums to bring your protest. You can bring it to the contracting officer or agency. You can bring it to the GAO, the Government Accountability Office, otherwise known as the Comptroller General, or you can bring it to the Court of Federal Claims. Again, most of the deadlines that I've been kind of defaulting to apply to the GAO. They're often the same with the contracting officer. The reason I default to those is because there are no strictly set deadlines with the Court of Federal Claims. However, the longer you wait, the more prejudiced you likely are, the longer the contract could be going forward, etc. Generally speaking, in terms of expense and level of formality, contracting officer is less expensive and less formal than the GAO, GAO is a little bit less formal and less expensive than the COC, the Court of Federal Claims, COFC. Now, the GAO has now gone to electronic docketing and has now implemented docketing fees, so it's kind of closed the gap a little bid between itself and COFC, but it's still a little bit easier and less formal to navigate than protests before the Court of Federal Claims. Next slide, please. And finally, what do you need to file? In terms of what you need to file, it depends on forum. When you're talking about the contracting officer or the GAO, you generally file a letter with attachments, outlining all of your arguments. The substance is going to, in the Court of Federal Claims, you have to file a formal complaint, and then if you're going for a stay, there are additional documents you need to file. In terms of substance, it's going to be across all forums the same. You're going to want to, as much detail as possible, describe every potential basis you see for a protest and what relief you are seeking. So again, that's just a brief overview. All of these issues can get very complicated, but just to understand a quick summary of the, the where, the why, the how, and the when, that is your quick summary. So that's all for me. I'll turn it back over to Mallory.
Thank you, Maria, for sharing your knowledge and insight today. Today's presentation has been recorded and can be found on our website or YouTube channel within about 48 hours. If you have questions about today's topic, please contact Maria at the phone number or email shown on your screen. Thank you, everybody. This concludes the webinar.